Okay. 16 point or 10.64. I think we agreed to give that one, right?
Okay.
I changed it. Yeah. I just changed it. And then there was going to be a possible addition.
I'm sorry. I'm completely lost. We're on 14.70, and you went back to 10 something.
No, I misspoke, and then I said 14.70.
I'm sorry. I didn't hear you.
I did go. I miss. All right. 14.71. I'll give that.
That's the new one?
Yes.
The one line. The one sentence.
Yes. I'm going by his new ones as best I can. 14.72. Unlawful injury. I'll give that. And now I have 14.73.
Submit it.
Which I didn't have before, I guess.
We did.
Did you?
But the new one looks appropriate.
Is it okay?
Yes, sir.
All right. And then I have 14.74.
I can see there's a typo. There's a number of brackets eliminated and so forth. We need a minute to figure that out, if we could, please.
Yeah. Threatened aura third person.
Aura.
Aura.
And I guess the number 1 should be removed, since.
Yeah. So take out the number 1 and put a space in, or a third person. And then it appears to be all right. I'll give that with those corrections. 16.135?
That's withdrawn.
Withdrawn. 17.02.
Yes.
That's withdrawn? Or that's the new one? There was a 17.03.
Well, 17.02 was not requested originally, but.
Right.
But it is now.
It needs to be given.
It is now and it should be given, right?
Okay. And 17.03 should not be given, right?
Correct.
I believe that's true, yes.
So that's withdrawn.
17.10. Do we have a 17.10 was submitted originally and then it's been withdrawn?
Is that correct?
It should be given, though.
But I think it should be given, and it should be tailored to meet the particular lesser.
Okay. What we'll put on that 17.10 is, and this has to be filled out, if you are not satisfied beyond a reasonable doubt that the defendant is guilty of the crime charged, you may nevertheless convict him of any lesser crime if you are convinced beyond a reasonable doubt that the defendant is guilty of the lesser crime.
It should say, a lesser crime. But it's not a big deal. Oops.
The crime of furnishing alcohol to a minor is lesser to that of administering an intoxicating agent to a minor charged in counts 7 through 10. And then down at the bottom, we'll reiterate the counts 7 through 10. The next one is.
And we agree to that, without waiving the objection to the lesser, but we agree that that's otherwise correct.
17.12. That hasn't been filled in. Does that have to be given now? Mr. Snedden, does 17.12 have to be given now?
I think it does, Your Honor. And I do not believe, in the packet of the verdict forms, there was a lesser included, so I'll have to do that.
Okay. Do you want to get somebody working on that?
Well, as soon as Mr. Franklin comes back from the other thing, I'll send him up to start on that one.
Okay. And then there's 17.24.1. 17.24.1 is the enhancement allegation, substantial sexual conduct.
That's under 1203.066.
Yeah.
I take it.
I think that's the proper, but there will be a finding included in the form for that. Then 17.30. Jury not to take a cue from the judge, we'll give that. 17.31. All instructions not necessarily applicable, we'll give that. 17.32.
That should not be given. I guess both sides thought Your Honor was going to be more vociferous.
Don't you think this would be a good case for me too?
Maybe.
All right, I'll reject that.
Your Honor, you realize we're all speaking in code to the extent that nobody in the court knows what we're talking about.
Oh, yes. The instruction 17.32 is an instruction that the judge may comment on the evidence, which in England is done regularly by judges, and in the United States is not done very often by judges. In fact, in my career I only had one judge do that, and he was reversed for doing it. So it's not something I would have ever done or intend to do this time.
I did remark, Your Honor, that if we had televised today's proceedings, we could have deterred an entire generation of kids from going to law school.
Okay, and 17.31. All instructions, 17. 17.31. All instructions not necessarily applicable.
That was already in there.
Okay, and then 17.40.
17.40. Oh, wait, 17.32 we did do, which is. That's the one you're not giving.
When the judge does not comment on the evidence. And then.
I'm sorry, Your Honor, maybe I'm losing it, here.
They didn't put it in their new.
Which one, Judge?
.30 you gave. .31 you gave. .32 you're not giving, I believe.
No. .31 I'm giving.
Yes.
17.32 is. I have not.
This is the one you're not giving.
All right, you're right. 17.40. There is one that I did that says I am not.
That's .30.
That's .30. Okay. 17.40.
I think that's correct.
I'm giving. 17.41 I'm giving. 17.42 I'm giving. 17.43 I'm giving.
Judge, we didn't know, on the second paragraph there, on 17.45, we didn't know exactly what format the court was going to be giving these in, but that may be that should be deleted, because it looks like the court's going to be giving clean copies to all the jurors.
Well, actually, the whole thing should be changed, given the court's proposed course of action.
Yeah.
I think we should say the jurors will each be given their own copy of the jury instructions which they may mark on if they wish. There will be one official copy of the jury instructions which shall not be defaced in any way. That's what you have to tell them, I think.
Yeah, I think you're right. This we should give at the beginning of the instructions, though, instead of the end.
Yes, that's a good idea.
Let's come back. We'll modify that a little bit. And 17.47. Admonition against disclosure of jury balloting. Are they going to receive a separate verdict form on each of the crimes? I guess. So I'll give 17.49. And 17.50 I'll give. Concluding instruction on selecting a jury foreperson.
17.49. I didn't see. Where's .49? Let me just see. Here. I'm sorry to go backwards, Your Honor, but on 17.49, the one currently submitted by the prosecution does not take into account the lesser included, and I think that language has to be put back in there.
I think it's all right, though, as long as the return of the one we still have to have, the partial verdict form instruction, is complete.
Maybe it's because it's the end of the day, but does that cover?
I think this needs to be given, because what will happen is if, on the lesser part, if you don't give it, they may sign it thinking that if they've convicted on the larger, they're supposed to sign on the smaller also, and it's a matter of clarification for them in terms of what their role is in terms of the lesser and the larger.
Do you mean, you're talking about 17.49?
I thought that's what Mr. Sanger was talking about.
Yeah, 17.49.
He just wondered if there should be a statement of the lesser included in that paragraph. It says, you've been charged with 1 count of conspiracy, 4 counts of lewd act upon a child, 1 count of attempted lewd act and 4 counts of administering an intoxicating agent.
Well, I understood that he was also suggesting that the second larger paragraph be reinserted, because it was not in there.
Oh, I don't have that.
No, sir. That's because we didn't envision lessers at the point in time.
So you think it should go in now?
I do, Your Honor. I think that's what counsel was talking about, and I do agree with him. The language is, since a lesser offense is included in the greater, you are instructed that if you find the defendant guilty of the greater offense, you should not complete the verdicts on the corresponding lesser offense.
Okay.
And those should be returned to the court unsigned. I think that's important. Otherwise, they may misconstrue the way the verdicts operate. And I'm not suggesting the last paragraph be left out. I'm just trying to direct them where.
The last paragraph would be more beneficial to the defendant, so there's one for each side there, and both should be in.
I agree. I just wasn't going to read the whole thing.
So now you want us to put in the entire instruction as it appears in the book?
I think if we have a lesser, I think you should do that. That's what he's saying.
Separation admonition. The admonition to alternate jurors. I'll give 17.53.
You're way ahead. You said 17.50?
Yes.
That's where I was, 17.50. Did you go beyond that, Your Honor?
Yes. 17.52.
Okay.
And 17.53. And then there's this post-verdict admonition, which I won't give to them in their package now.
Right.
Judge. This is sort of a new CALJIC 17.54. I didn't request it. I just happened to notice it, but the basics of it is that people not take cell phones into the jury deliberation room.
They're not allowed to bring in cell phones now.
Okay. This is a new instruction. I mean, I just didn't know whether. It looks like the problem's taken care of. We don't need to give it.
What number is it?
17.54. And they cite a case, but
It replaced the old one that had to do with bringing Ouija boards in. I don't think it's mandatory. In fact, it says if you're going to do it, you should do it as part of the pre-instruction back in the beginning of the case under 0.50. But if the court staff and the bailiffs are not allowing the jurors to have cell phones to start with, I think saves the problem. Whatever the court wants to do.
That's the case, isn't it, Leslie?
It is. They do not have cell phones.
I should give 17.47, too. Did I give that? Yeah, I did. Okay. CALJIC 16.0.10.010?
we withdrew that.
Well, but where we were. Where are we going to put it in the?
Oh, is that the BNP one?
I read it earlier.
Is that the BNP one, Your Honor?
Yes.
Oh, I'm sorry. I was thinking of another one.
I read to you what I would do, and then we needed the, that should go. What? Right next to the other charges. What number are they?
Well, you could put it right after your instruction on the lesser included offense.
Do you mention?
Well, there's 222, which is a special also.
Yeah. I'm not seeing 222. That's the problem.
That's where it goes. Did you see it? Did you not get it?
I can't say I didn't. I cannot say I did not get it, but I do not have it.
It was in your original package, but it's not in your new package, Mr. Snedden.
I'm sorry, Your Honor. What section is that?
222, which is the Penal Code Section 222 Special, administers to another any intoxicating agent with intent to. And that's the one that this lesser should be with. I'm going to put it right after. Both of those right after the extortion, but I don't understand. Your instruction has elements, and then nothing after that. Have you seen it? Do you both want to approach?
Yes. Discussion held off the record at sidebar.
Tracy, and then the furnishing, that goes behind it.
In between those two, would you not put 17.10?
Put what?
17.10, in between the.
Do you mean 17.12?
No, 17.10.
Lesser included. Okay.
Now, did that 222 start out with, in the crimes charged in counts 7 to 10?
No, it says, any person who administers to another any.
I think it should start out, because that was the typical introductory paragraph. Just a paragraph that says, in the crimes charged. How does it start out in the other ones? Not the conspiracy ones, but the others?
No, it doesn't.
Well, for instance, 10.41, the defendants accused in counts so and so.
9.70 just says, defendant is accused in count 1 of. Is that what you're talking about?
Yeah, so we need to say, the defendant is accused in counts 7 through 10 of.
Okay.
Whatever it's called.
Did you get that, look at the extortion one, or the child abduction one, and you'll get the opening sentence to it.
Not quite, because that says, conspiracy to commit, I think.
Okay.
So it should just be, the crime of. I was looking at 10.41 as being a good example. The defendants accused in counts 2, 3, 4 and 5. Here it should be, the defendants accused in counts 7, 8, 9 and 10.
Now, I think what we have left are the specials, is that right?
Yes, sir. And then also, those also may or may not have an impact on a few of the instructions we tabbed.
Okay.
We have special number 1.
Which ones?
Those are your original instructions, and I think the court considered that way back when the thing was played.
And we did do you have the transcript, Tracy or Jed, of the instruction I actually gave when it was played?
Yes.
I had it this morning. Because we took part of yours and part of the district attorney's at that time.
When the court's ready, I would like to be heard briefly on this theory that I think Your Honor was rejecting, but
Wait till we get to it. We haven't done it. I was just indicating my feelings.
Okay.
Okay. On special jury instruction number 1, I'm willing to give that instruction, without the middle paragraph, in this form. The video of Living with Michael Jackson is not offered for the truth of anything said or shown in the program, with the exception of certain identified passages. You will receive additional instructions with regard to those identified passages. The rest of the contents of the video is hearsay and cannot be considered by you to prove anything other than the fact that the program aired in February of 2003 and its likely impact on Mr. Jackson's state of mind. And then skip the middle paragraph. And then, you should not be biased, prejudiced or influenced in any way by the content of the video or by its commercial packaging. Except for the limited specific statements that the court will instruct you. Except for the limited specific statements that the court will instruct you may be considered. The remainder of the program should only be considered for the fact that it aired and its impact on Mr. Jackson.
Can we say, its impact, if any, on Mr. Jackson?
Yes.
Judge, may I make a comment?
Yes.
I thought the additional circumstantial basis for the admission of it was to show the motive for the crime, of the conspiracy. And that goes a little bit beyond merely Mr. Jackson's, any impact, if any, on Mr. Jackson's state of mind. It goes to the actual motive for forming or need to form the conspiracy. So maybe something like, any relevance it may provide, if any, on the motive for the conspiracy, or something like that.
Well, one way to accommodate it, just to try to accommodate it at the end of the day here, you could say, its impact, if any, on Mr. Jackson or on other individuals mentioned in the course of the trial. But then if you say that, then we should say, it is up to you to determine what significance, if any, to place on this evidence.
Isn't there somewhere else in the instructions that we discussed the motive as?
Yeah, there's a general instruction on motive, which is, I think, 2.51, but you're actually, in this one, you're being very specific about this piece of evidence and what the limited purpose of it is.
When I say, its likely impact on Mr. Jackson's state of mind, aren't we saying that then you can argue that the impact is motive? I mean, should I have motive in the instruction if I'm saying that it was introduced to show the impact on him?
I just didn't want to get in the position, Your Honor, of having someone stand up and make an argument and start talking about motive in this connection and then saying, you know, it's really for his state of mind in terms of whether he was angry or upset about the production.
No, I think that's one of the states of mind. That's what we're talking about, is in his state of mind of whether or not that was a motive to do certain things that you allege he did based on that video.
Well, I'm comfortable with what the court's saying as long as everybody understands that. I just didn't want to have to argue an objection on that, because I think that was one of the underlying reasons.
Okay.
Alright, I think that's sufficient and it can be argued.
Okay.
Do you want to have our office retype this?
No, I think we'll do it. To Mr. Beebe, do you have a problem?
We're not clear what the language is now.
It's exactly what's here except where I wrote in, if any, in red.
Okay.
Judge, when you say, exactly what's here, that's different from the defense instruction, correct?
Right. It's what I just read.
Yeah, thank you.
Now, the second instruction was,
It might be helpful to look at proposed instruction number 5 because I think that special instruction number 5 would follow this instruction.
well, okay, I'm just going to reject special instruction number 2. So I'm giving number 1. As modified. Reject 2. Refuse 2. And then we go to the ones you filed this morning. Number 3. I'll give number 3.
Your Honor, may I be heard on that?
Yes.
Judge, I think that's a misstatement of the law. And I'll tell you, first of all, I object to the use of the word government. Second of all, I don't see one CALJIC instruction that uses the word government anywhere in it. But second of all, I don't believe that it's the law that the jury necessarily has to agree to the particular set of facts that make up the charges. For instance, let me just give you an example. If all the jurors agree that Mr. Jackson placed his hands inside of the child's pants, it's not necessary for the jury to agree that he had underpants on at that time, or he had pajamas on at that time, or he had a shirt on at that time, or he didn't have a shirt on at that time, or that Mr. Jackson had his socks on at that time, or he didn't have his socks on at that time. And I think that's what's misleading about this, and that's what happens when you stray from the standard instructions, and this is a very misleading instruction.
Well, nothing happens if you stray from the standard instructions if they don't cover the law. If they don't cover the law, it's reversible, so we have to do something in light of Blakely and Apprendi and the cases after it that there has to be unanimity, particularly when the charges are alleged in such a broad fashion. So the prosecution has to, in essence, opt for a set of facts. I would agree with Mr. Snedden, of course, it doesn't, matter. The details don't matter as to whether or not the jury agrees on the set of facts that make up the elements. But you can't have 6 jurors agreeing to one occurrence, and another 6 jurors agreeing to another occurrence, and particularly in a case like this where you've had a lot of descriptions. You haven't had consistent descriptions for these various offenses. You can't have, say, one set of jurors saying, well, let's see, I believe that Starr's story was correct and I don't believe Gavin's, and the other saying the other way around. Either it's, so we have to accommodate that somehow.
Well, I think the standard instruction does that. It tells them they have to deliberate on each count separately and arrive at a decision on each count separately.
It says, particular set of facts as alleged in a particular count, so, that is saying it's the facts alleged in the count.
No one say anything. We're off the record.
Oh, okay. Discussion held off the record at sidebar between the court and the court reporter.
Where's Commander? If I take a 10-minute break and go for another half hour after that, what's it going to do to you?
No problem.
We can do it? Okay. I just want to take 10 minutes. And this is a pretty serious part where we are, the last 6 instructions. I don't want to rush them, and the court reporters consented to work. She's the one that's the most affected by this, next to security. So let's take 10, and a short break, and then we'll come back and deal with and maybe you'll have your things by then.
I've got the verdicts already. I'll give them to you.
And the changed instructions?
Jerry's working on it.
What I'm feeling is I can't really finish the instructions the way I want to do it, and I don't like working under the pressure of worrying about other people here and myself. I'm not satisfied with any of the specials proffered by the defense. But I feel that we have not, none of us have put together a good jury instruction on the tapes, all of the tapes. We have 4 tapes that they have watched, and there's some very limited uses that each of those tapes can be used for, and there's no instruction here that adequately guards against misuse. So I'm not going to proceed. I'm not going to go all this distance and then try to rush, in half an hour, to get something done that needs to be done.
Can I add something to the court's concern?
Yeah.
And I hate to be the bearer of these tidings. We were looking at the lesser included, which we objected to. And since we objected, I suppose I could just leave it on the record like that, but as I was talking to Mr. Dunkel, he had the added observation that actually 222 doesn't have the same elements, because 222 doesn't require a minor. And remembering case law on lessers, where it has to be exactly the same elements, -1 or 2, that's an issue. And then furnishing is not the same as administering. So I want to give the court a fair opportunity on that. I didn't want to not mention it, but if we are going to have to change that, that's something that's going to be more than a 2-minute change to go back.
Yeah, well, and I haven't also got to review the materials that you typed in a hurry and brought down, and the verdict forms, and since I'm putting packages together for the whole jury, I don't want to be doing it at the last minute. I think what I should do is continue the jury instruction conference until tomorrow morning at our regular time. Then the question becomes, when do I have the jury come back in? And I could have them come in at noon, at our normal noon recess. That would give me an hour. If I instructed from, around 10 o'clock to 12 o'clock till. Reading these instructions is probably going to take over an hour. So that would put me at 1 o'clock or so. And then that would start Mr. Snedden with his argument. Or I could have you come back in and do your argument on Thursday morning. But it seems to me even bringing the jury in just to instruct them is worth it. Considering trying to get the case out by Friday, late Friday, that it would be a wise thing for me to at least instruct tomorrow.
That seems like a good idea, and it does seem that there's probably nothing wrong with the jury just getting the instructions on the law one day. It has.
It's not a very good use of time, but considering that we want to do this right and not be rushed into decisions that are not good ones, I think that's what we'll do.
Judge, my preference would be to have us not start argument after you give the jury instructions tomorrow. And I guess part of that still has to do with whether there is or is not any time limitations that might drive that decision, too, which we have not decided, and which we really need to come to grips on, but I don't think we need to keep all the staff here to do that.
No. Well, we can. I think what we'll do is recess and let everyone go. I'll have one attorney from each side come back and we'll discuss time limitations on your argument, and then I'll work on the rest of these instructions. And we'll start at 8:30 tomorrow morning.
Just before you break, on the issue of what comes in for the truth of the matter on the tapes.
Yes.
Could I just be heard on that very briefly? And I know it's keeping staff. I'm sorry, but we did try to go through and outline what would be relevant. The problem with doing that is that even if we were to agree, or it doesn't matter if we don't agree, the court decides, then the court has to sit there and read that to the jury, which then has the effect of unduly emphasizing both sides. I mean, you're reading specific statements of Mr. Jackson either from the Bashir tape or from the outtakes. And that's why, it was not out of laziness. It was after reflecting on it, that if you can do it generically, what ultimately in this case would be the harm? I mean, there's very limited statements in the Bashir tape that pertain to Mr. Jackson's relationship with children, which is what the prosecution wants to bring in, and it has to be statements of Mr. Jackson and relating to children, and there are pretty much identifying statements in the outtakes. I don't think there's a big danger in doing it that way, and what it really avoids is the court, having to read from both tapes and unduly emphasizing the text. So I just wanted the court to understand that was our theory behind it. Now, if the court wanted to have the parts that we believe should be read by the court from the outtakes, we could.
I never asked to have the material given to me so that I could read it to anybody.
Okay.
It never was my intent. It was so that I could see what the district attorney was going to argue were admissions so that I would have a sense of what I could allow you to put in, to show the complete context of those statements, which is what I think you're allowed to do, but I never thought you were lazy either. I thought you were. You thought it over and you thought, well, it would be good if everything he ever said about children could be taken for the truth of the matter asserted, and I just didn't think that was a good way to approach it.
Judge, well, I do need to make a statement about that. The reason I think it's very important for us to have some agreement and consensus on what statements do constitute the admissions part is that during the course of the arguments, if the defense attempts to use something for the truth of the matter, there is some guidelines as to what it is the court recognizes as hearsay and not hearsay. So there's another reason for you to decide that, not to read to the jury, but that both sides know what the boundaries are,
I agree.
Okay, thank you.
There's a preliminary determination that is not binding on the jury, because ultimately whether something is an admission or not is up to them.
Correct.
but the court has the duty of making a preliminary look at the material and not allow them to be considering admissions that aren't admissions. So then we'll see. Well, first of all, two of you come back on the time issue, and other than that, we're through for the day.
12 o'clock for the jury.
That's what time they're in the courtroom, not when they're supposed to get there. So having them here at 11:30 might be the right time to have them.